Your Excellencies, students, ladies and gentlemen. It's a really great pleasure for me, being the Vice-Chancellor of this university, to welcome you all to this year's Anna Lindh lecture. And we are really honored to have Margaret Sekaggya here, lawyer and Executive Director of Human Rights Center in Uganda, and a former United Nations Special Rapporteur on the situation of human rights defenders, that you have accepted our invitation and come here to give us a lecture. And it was not long ago I welcomed international students, and some were from Uganda. Human rights is really important for Lund University, so I'm so proud of the research and education that we have here at our university. Education both on undergraduate level and on graduate level. And it takes part on many parts of our university. The Raoul Wallenberg Institute of Human Rights and Humanitarian Law is a key player within the university, with its long-standing reputation in Sweden and abroad. This year, the Institute celebrates its 30 years anniversary, and I would like to take this opportunity to extend a thank you for the research achieved and best luck of the coming years. Both Raoul Wallenberg and Anna Lindh are role models who have demonstrated that one person can make a difference, thus inspiring young people all over the world and all of us. The dedication and work they made really a difference towards a better world and served as an inspiration to a younger generation and to all of us. Tomorrow is the 24th of October, and the entire world will celebrate the United Nations Day. The value upon which United Nations was founded remains as valid as today, as they were during when the UN Charter was adopted during the Second World War. Lund University is also pleased with the cooperation with one important and active student association, the Association of Foreign Affairs, and the Anna Lindh Memorial Foundation. The event today is framed by music by Akademiska Kapellet. And I'm very happy that we have all joined forces for this annual event in memorandum of Anna Lindh. Immediately after closing of this ceremony, we all are most welcome to attend the reception which will be held inside this building. Once again, warm welcome to all of you.
Magnificent Rector, Excellencies, students, ladies and gentlemen. It is my great pleasure to introduce to you Madam Margaret Sekaggya to give the annual Anna Lindh lecture. Madam Sekaggya is an old friend of the Raoul Wallenberg Institute, and it is not the first time she is visiting Lund. In 1991, the UN General Assembly adopted principles relating to the status of national institutions, the so-called Paris Principles. These mean that states are called to establish a national institution with competence to promote and protect human rights. Such a national institution shall have a number of responsibilities. The most important are to examine any violation of human rights which take place in the country, and the formulation of programs for teaching of and research into human rights, and to take part in their execution in schools, universities, and professional circles. In 1996, when the new government had come into power in Uganda, it was decided to establish a Commission of Human Rights in conformity with the Paris Principles. Madame Sekaggya, who in those days was a judge of the High Court of Uganda, was requested to be the chairperson for the interim electoral commission, which later became the Uganda Human Rights Commission, and Madame Sekaggya became the first commissioner. It was in those days, by the way, that Madame Sekaggya visited Lund together with all other commissioners. The Uganda National Human Rights Institute is one of the oldest commissions. It's one of the strongest in Africa. The Commission investigates all violation of human rights. It can be decided that the matter should be heard by a tribunal, which will lead to a binding judgment. The Commission can mediate between the parties. It can order the release of a detained person and even order the payment of compensation to an alleged victim. It has also a right to take initiative of its own by visiting prisons and places of detention. An additional task of the Commission, equally important, is that it is responsible for civic education and teaching of human rights. As a parenthesis, I would like to stress that there is no national human rights institution in Sweden. Another declaration adopted in 1999 by the UN General Assembly is a declaration on the right and responsibility of individuals, groups and organs of society to promote and protect universally recognized human rights and fundamental freedoms. It's a long title and a long declaration as well. But it is not binding. It's not a binding document, and the declaration repeats provisions already enshrined in other human rights treaties. As such, the declaration is of minor importance. However, attention was paid to human rights defenders, that is, persons who try to defend others from being violated and who, because of their activity, fear reprisals by the state. To implement the declaration, the UN Commission of Human Rights decided to appoint a special rapporteur on the situation of human rights defenders. And between 2008 and 2014, Madame Sekaggya acted as a special rapporteur appointed by the UN Human Rights Council. The protection of human rights defenders is a most sensible task. It presupposes devotion to human rights, an extraordinary knowledge of human rights, and last but not least, diplomatic skill. To assist victims, the rapporteur will have to negotiate with governments who frequently are hostile. Within UN, the activity of Madame Sekaggya is most appreciated. More importantly, non-governmental organizations highly speak about the results of Madame Sekaggya. She is also the founding member and executive director of the Human Rights Center in Uganda. She herself is a human rights defender. She is also, this year, the Uganda Female Lawyer of the Year 2014 award. Madame Sekaggya, you have the floor, please.
Your Excellencies, dear students, ladies and gentlemen, I must start by thanking the Raoul Wallenberg Institute, the University of Lund, and the Anna Lindh Memorial Foundation for inviting me to address you today. It's a great honor. Thank you. Thank you for inviting me. It is indeed a great pleasure for me. And I would like to thank you for inviting me to speak at the Anna Lindh lecture. As I said, I feel honored, privileged to speak at this event and to identify with a memory of a person whose life and career had an impact on the promotion of universal respect for human rights. I know that Anna Lindh was a human rights defender. Today, I will speak on a topic which is very close to my heart. As UN Special Rapporteur for the last 6 years, I've been writing a number of reports. I've been going around different countries. So far, I visited about 45 countries. I've been writing thematic reports. And at the end of it all, at the conclusion of my mandate, I realized that the most important issue for human rights defenders is to create a safe and enabling environment for human rights defenders. So my last report to the Human Rights Council was an appeal to the Council to ensure that defenders work in a safe and enabling environment. I've continued to advocate on this subject, and I thought there wasn't a better topic for me to continue the advocacy and struggle for human rights defenders than to address this august audience about the need to create a safe and enabling environment for human rights defenders. As you all know, it is important to note that the primary duty and responsibility to promote and protect human rights and fundamental freedoms, including the rights for human rights defenders, lies with the state. States have the obligation to undertake the required steps to create all conditions necessary, including in the political and legal domains, to ensure that everyone under their jurisdiction can enjoy all these rights and freedoms in practice, including the right to promote and defend human rights, regardless of the status of the alleged perpetrators. States must protect human rights defenders from any violence, threats, or any other arbitrary action as a consequence of their legitimate exercise of their work. This obligation also extends to non-state actors in certain circumstances. What are some of these issues which I've pondered about over the years as the prerequisite for creating a safe and enabling environment? I'll discuss some of them today with you and share my thoughts about them. And maybe later on we could see whether our minds converge. One of them is creating conducive legal, institutional, and administrative framework. One of the key elements of a safe and enabling environment for defenders is the existence of laws and provisions at all levels, including administrative provisions that protect, support, and empower defenders, and are also in compliance with international human rights law and standards. Moreover, institutional frameworks should be shaped in such a way that they are receptive and supportive of defenders' work. As you all know, in countries where human rights are specifically recognized and protected in domestic law, those rights are more likely to be respected and realized in practice. Beyond their normative value, I believe that human rights law can have an important educational role in that such laws signal the values for which a particular society stands. The adoption of laws that explicitly guarantee the rights contained in the Declaration on Human Rights Defenders is crucial in that it could contribute to building an enabling environment and give these rights legitimacy. Furthermore, such laws could contribute to building wider societal support for the demand of fulfilling these rights. Indeed, there are a number of states that have passed legislation that guarantee the rights of human rights defenders, particularly in access to information held by public authorities, and protect those who disclose public interest information that is relevant to the promotion and protection of human rights, and those who report on corruption by public officials. However, legislation is also used in a number of countries to restrain the activities of human rights defenders and criminalize their work, which is in breach of international human rights law, principles, and standards. Legislations such as the anti-terrorism and public security laws, anti-homosexuality laws, public morals, defamation, access to information, are sometimes used to restrict the work of defenders. There are also restrictions on the types of activities that associations can engage in, such as political rights advocacy. Moreover, there is a disturbing trend towards the criminalization of activities carried out by unregistered groups. Furthermore, there are restrictions on funding from abroad, which have been introduced in a number of states. This leads to associations risking treason charges, having to declare themselves foreign agents, or having to seek prior approval to fundraise. Ladies and gentlemen, that's one of the issues I've considered over the time. The second one is to fight against impunity and access to justice for violations against defenders. In many cases, complaints by defenders about alleged violations of their rights are not investigated, or sometimes are dismissed without justification. A state's lack of investigation into violations could be seen as condoning attacks against defenders and could nurture an environment where further attacks are perceived as tolerated. Therefore, ending impunity is an essential condition for ensuring the protection and safety of defenders. States should ensure prompt and independent investigation of all violations against defenders and the prosecution of alleged perpetrators, regardless of their status. They should also ensure for victims of violation access to a just and effective remedy, including appropriate compensation. The provision of an effective remedy should be understood as access to judicial and administrative or quasi-judicial mechanisms. Investigation and prosecution should rest on an effective and independent judiciary. States should implement the interim measures of protection granted by international and regional human rights mechanisms to defenders. Unfortunately, in many instances, weaknesses in the judicial system and flaws in the legal framework have deprived defenders of adequate tools of seeking and obtaining justice. Therefore, strengthening the judiciary and making sure that it can operate independently and effectively should be a priority for states. The other one, which has already been deliberated on, is establishing strong, independent, and effective national human rights institutions. As part of the institutional architecture of the state, national human rights institutions can play a key role in ensuring a safe and conducive environment for defenders. National human rights institutions that comply with the Paris Principles are in a unique position to guide and advise governments on their human rights obligations. They can also ensure that international principles and standards are adequately incorporated into domestic law and mainstreamed into public policies, including that of human rights defenders. Evidence shows that when the mandate of the national institutions, including competence to investigate complaints and provide effective protection, if it's provided, they can play a leading role in cases where states' judicial systems are unable or unwilling to adjudicate on alleged violations against defenders. It has been strongly recommended that national institutions have a designated focal point for human rights defenders with responsibility to monitor their situation, including risks for security and legal and other impediments to a safe and conducive environment for defenders. However, there are also violations against national institutions, their members and staff, ranging from attacks, threats and intimidation to harassment and stigmatization in connection to their human rights work. Such constraints and challenges can seriously undermine the independence, efficiency, credibility, and impact of these institutions. Therefore, states need to protect by law and publicly support national institutions and their members and staff when necessary. In order to ensure the credibility of the work of national institutions, government must be responsive and ensure adequate funding and follow up on implementation of their recommendations. This is particularly important given that most of these institutions have advisory functions. Therefore, government should proactively implement these recommendations and follow up and be tracked and evaluated. The other aspect, which is also important for human rights defenders, is effective protection policies and mechanisms, including public support for the work of defenders. It is necessary to use public policies and specific institutional mechanisms to provide protection when it's considered necessary to guarantee a safe and enabling environment for defenders. As special rapporteur, I developed guidelines that I believe are essential for the development of protection programs. Firstly, that human rights defenders should be consulted throughout the setting up or review of protection programs. That protection programs should include an early warning system. That the physical protection of defenders should not be outsourced to third parties unless these have received specific training. Furthermore, that adequate financial resources should be allocated to protection programs. There are a number of countries which have followed these guidelines, and you will be able to see them in my report. In an attempt to delegitimize their work and activities, defenders are often branded enemies of the state or terrorists. This stigmatization makes defenders even more vulnerable to attacks, especially by non-state actors. Therefore, as part of protection policy, it's of crucial importance that the work and role of defenders be publicly acknowledged by state officials at the highest level. I believe that a public acknowledgement of defenders' work could contribute to providing their work with due recognition and legitimacy. The other aspect which I considered is to address specific challenges of groups at risk. It's important to address the needs of human rights defenders who face extraordinary risks due to the work they do and the context in which they operate. In this connection, as special rapporteur, I focused on the situation of selected groups of human rights defenders who are at particular risk of violations. These include judges and lawyers, journalists, media workers, trade unions, youth and students defenders, those working on sexual orientation and gender identity, and defenders working on environmental and land issues. Journalists and media workers are targeted because of their reports on human rights violations or because they have been witnesses to human rights violations. They are particularly exposed to violation in contexts such as armed conflicts, post-conflict situations, and situations of unrest in connection with coups d'etats or contested elections. In many countries, legal frameworks are used to restrict journalists and media workers' activities. Restriction on media and press freedom and impunity could foster a climate of intimidation, stigmatization, violence, and self-censorship. With regard to youth and students defenders, because of their young age and alleged lack of maturity, these are used as grounds for not giving them a say in public affairs. There is a trend in many countries of passing legislation that prohibits young people from participating in public assemblies. Other legislative moves pertain to internet, social media, and instant messaging, which are increasingly subject to control by government. The other group that also face high risk and violations are defenders working on land and environmental issues in connection with extractive industries and construction and development projects. And violations in this regard generally occur in context of land disputes where the perpetrators are both state and not state actors. Communities and those defending their rights should be able to participate actively, freely, and meaningfully in assessment and analysis, project design, and planning and implementation, monitoring and evaluation of development projects. Defenders working with local communities can play a crucial role in facilitating communication between the communities. The increased criminalization of social protest, often in connection with peaceful expression of opposition to public or private development projects, is also a big issue. Authorities should grant defenders, especially journalists, media workers, access to public assemblies to especially facilitate independent coverage and human rights monitoring. The other aspect which is important for us today is special attention for risks and challenges faced by women defenders and those working on women's rights and gender issues. Integrating a gender perspective and paying particular attention to the specificities of the environment in which women human rights defenders operate is important. There are specific risks and challenges faced by women human rights defenders and those working on women's rights and gender issues, and there are repercussions that such work may have on partners, spouses, and family members of defenders. Women defenders are subjected to arrest, ill treatment, torture, criminalization, and unwarranted judicial proceedings, stigmatization, attacks, threats, including death threats, sexual violence, and killings. Furthermore, in many cases, the family members of women defenders are also targeted. In many countries, there are no specific mechanisms in place to protect women defenders and those working on women's rights and gender issues. In countries where such mechanisms exist, they are often hampered by lack of gender sensitivity, implementation, or political will. Women defenders need specific and enhanced protection and targeted and deliberate efforts to make the environment in which they operate a safe and more enabling and supportive one. The other aspect is the issue of non-state actors. Non-state actors should respect and support the work of defenders. Non-state actors include private companies. They can also play a key role in the promotion and protection of rights and activities of defenders. And therefore, in the consolidation of a safe and enabling environment for defenders, they should conduct their work in a special way. As special rapporteur, I have highlighted that it's paramount that non-state actors acknowledge and respect the important role of defenders in ensuring the full enjoyment of human rights. As special rapporteur, I received credible reports and allegations indicating that non-state actors, including private corporations, are involved in violations against defenders, including stigmatization, threats, harassment, attacks, death threats, and killings. And attacks are sometimes committed by groups which are directly or indirectly set off by states, either by providing logistical support or by condoning their actions explicitly or implicitly. Defenders working on rights of gay, lesbian, bisexual, or transgender persons are subjected to stigmatization and attacks, inter alia. Community and faith leaders or groups and the media. I raised the difficult situation of this group in various communications and during my country visits when I was special rapporteur. I recommend that authorities remove legal provisions that hinder and stigmatize these defenders' work and provide them with adequate protection and public support. The other aspect, which is important, is to have a safe and open access to the United Nations and international human rights bodies. The United Nations, the regional and international human rights bodies are part of the environment in which human rights defenders operate. Therefore, it's essential that defenders have a safe and unhindered access to such bodies for their work and their protection. The Universal Periodical Review mechanism contributes a safe and enabling environment for defenders. Given that the Declaration on Human Rights Defenders does not have a monitoring body, the Universal Periodical Review as a mechanism is an excellent opportunity to give visibility to the situation of defenders and contribute to their protection. I have elaborated a lot on the use of the Universal Periodical Review, including the need for consultation, the need to include defenders in the reports, and these will be found on my paper. The other aspect is, and it's important, is to have a strong, dynamic, and diverse community of human rights defenders. I do acknowledge that defenders themselves have a role to play in contributing to a safe and enabling environment. They are responsible for doing their work professionally, in a peaceful manner, and with due respect to international human rights principles and standards. I do encourage defenders to actively participate in constructive dialogue with the states, lobby for the adoption of laws on protection of human rights defenders, and monitor the progress of such laws. They should also lobby for the implementation of recommendations made by national, regional, and international mechanisms. Defenders should continue supporting the work of national human rights institutions by cooperating with them, advocating for their strengthening, and collaborating in the planning and implementation of their activities and programs. They should also advocate for the establishment of a national human rights institution in full compliance with Paris principles in countries where these institutions do not exist. Defenders should also create or strengthen platforms and networks in order to protect and promote themselves, as well as promote dialogue and coordination among themselves. Defenders should work together through networks and have a unitary, strong voice. In this regard, it's important that defenders work towards strengthening networks outside the capital cities and reach out to defenders working in rural areas, which are often more exposed to risks. I believe that it's crucial that defenders strive for high standards of professionalism and ethical behavior when carrying out human rights activities. They should also recognize the important work of women human rights defenders and those working on women's rights and gender issues and strive towards empowering them. It's also essential that defenders make full use of international and regional human rights mechanisms, including special procedures, the treaty bodies, the Universal Periodical Review, and the European Union guidelines on human rights defenders when reporting on human rights violations and breaches of international human rights law. I want to conclude and make recommendations that defending human rights is not only a legitimate and honorable activity, but a right in itself. However, defending and claiming rights continues to be a dangerous activity. In many parts of the world, states have the primary responsibility to ensure that defenders work in a safe and enabling environment, but non-state actors also have some obligations. Such an environment should include a conducive legal, institutional, and administrative framework, access to justice, an end to impunity for violations against defenders, a strong and independent national human rights institution, policies and programs with specific attention to women defenders, effective protection policies and mechanisms, paying attention to groups at risk, non-state actors that respect and support the work of defenders, a safe and open access to international human rights bodies, and a strong and dynamic and diverse community of defenders. I therefore make the following recommendations to the states: that they should ensure that defenders can conduct their work in a conducive and legal, institutional, and administrative framework. In this vein, refrain from criminalizing defenders' peaceful and legitimate activities, abolish all administrative and legislative provisions that restrict the rights of defenders, and ensure that domestic legislation respects basic principles relating to international human rights law. Again, to states, combat impunity for violations against defenders by ensuring that investigations are promptly and impartially conducted and perpetrators are held accountable. Victims obtain appropriate remedy. In this context, pay particular attention to violations committed by non-state actors. States should raise awareness about the legitimate and vital work of human rights defenders and publicly support their work. In this respect, widely disseminate the Declaration on Human Rights Defenders and make sure that human rights education programs, especially those addressed to law enforcement and public officials, include models that recognize the role played by human rights defenders. Provide national institutions with broad and solid mandates and make sure that they are adequately resourced to be able to operate independently and to be credible and effective. And publicly acknowledge and support the important role of these institutions, including in providing protection to defenders and fighting impunity. States should ensure that violations by state and non-state actors against defenders, particularly women defenders, are promptly and impartially investigated, and ensure that perpetrators are brought to justice. They should publicly acknowledge the particular and significant role played by women human rights defenders and those working on women's rights and gender issues, and make sure that they are able to work in an environment free from violence and discrimination of any sort. and they should provide necessary training to public officials on the role and rights of defenders and the Declaration on Human Rights Defenders. States should ensure that public policies, including development policies and projects, are developed and implemented in an open, participatory manner, and that defenders and communities affected are able to effectively, freely, and meaningfully participate. They must make sure that defenders can participate in the Universal Periodical Review, including by raising awareness about the process. Ensure that acts of intimidation and reprisals against defenders who engage with the United Nations, its representatives and mechanisms in the field of human rights and international human rights bodies are firmly and unequivocally condemned. And ensure that these attacks are promptly investigated, perpetrators brought to justice, and any legislation criminalizing activities in defense of human rights through cooperation with international mechanism is repealed. To the international communities, Your Excellency, acknowledge and support the legitimate work of human rights defenders, both through the public recognition of their role and the provision of technical and financial assistance to increase their capabilities or enhance their security if needed. Ensure safe and open access to international human rights bodies, in particular the United Nations and its representatives and mechanisms in the field of human rights. To non-state actors, recognize and respect the work of defenders in accordance with the Declaration on Human Rights Defenders and refrain from violating their rights or hindering their activities. Involve and consult human rights defenders when carrying out country assessments and develop national human rights policies in cooperation with defenders, including monitoring and accountability mechanisms for violations of rights of defenders. That non-state actors should familiarize themselves with the UN guiding principles on business and human rights and with human rights impact assessment of business operations. To human rights defenders, I wish to appeal and recommend that they should actively participate in constructive dialogue with states to encourage it to consolidate a safe and enabling environment for defenders, including by providing inputs on the potential implication of draft legislation. Defenders should familiarize themselves with the Declaration on Human Rights Defenders and disseminate it widely at the local level. They should continue supporting the work of national human rights institutions, continue working together through networks, including by strengthening and supporting networks outside capital cities to reach out to defenders working in rural areas. And they must strive for high standards of professionalism and ethical behavior when carrying out human rights activities. And they should continue to make use of existing international and regional human rights mechanisms, including the United Nations, its mechanisms and representatives in the field of human rights. These are some of the issues, and many more appear in my reports, which are all posted on the website. But I thought if we can address some of these issues, then we could make or provide a safe and enabling environment for human rights defenders. I thought these are critical factors to consider. So, Your Excellencies, ladies and gentlemen, I thank you for listening to me this evening. And I hope that these deliberations will be taken to your home countries, to your areas, to implement what is in this report. I thank you very much.
Ladies and gentlemen, Margaret has agreed to take a couple of questions from the audience. Do we have any questions? Just raise a hand. You one gentleman over there. You take 3 in a row. If any more questions?
I need my pen.
And then there is one there. Yeah.
Firstly, my name is Fraser. I'm a student on the International Human Rights Law programme. I'd like to firstly say thanks for your address this evening and for your previous and continued work in advancing human rights protection. My question relates to something you touched early on about the foreign agent law that we see in some countries such as Russia and Azerbaijan and lately Hungary. I was wondering, in your opinion, what do you feel the international community could do to provide support to these NGOs that are facing stigmatization and constraining restrictions imposed by domestic legislation? Thank you.
Good evening. I read in the news this year H&M, the Swedish clothing company, made a donation of €500,000 to civil rights defender. Can you hear me now?
I can hear.
Okay. To civil human rights defenders. And could you please elaborate whether this is an unusual practice? What is the level of donations human rights defenders organizations receive from the corporate sector? And whether you expect such companies to also raise their voice in support of human rights defenders in addition to financial donations? Thank you.
One more question? No, please.
The foreign agent law and in issues of funding and support to NGO facing stigmatization has been a big issue for me during the period of my mandate, especially in some of those countries where defenders are supposed to declare themselves foreign agents or working for foreign agents if they get support. In some of the other countries, these are limits on the percentage of the funding an NGO could get. In other countries, there is provision that that funding should go through another organization before it's given to the organization. And I have found that in those instances, many of the institutions have almost collapsed. It's been very difficult for them to operate because, as you know, most of the NGOs rely on foreign funding. There is no government which gives enough money to civil society organization to be able to run, because the civil society is supposed to be another arm which is checking government. So I don't know what to advise, how these organizations could be supported, but some of the instances I've seen that organizations have been networking with the national human rights institutions to be able to do some activities, and that the government is not very strict as to how much a national institution gets. So when the organization, the national institution is given the money, then the organizations could do some activities with a national institution. However, it's a very big challenge. It's one of the issues, and there is almost a special report on funding and the stigmatization of NGOs for receiving funding. It's a very big issue. We just have to advocate to ensure that these laws are not passed, challenge them in courts of law, challenge them in our own countries, and get our ambassadors and other people to also advocate that these laws would strengthen the work of human rights organizations. As to financial donations, I didn't get your question very well, whether you are saying this is a corporation giving the financial donation. Was it the question? If a corporation gives a financial donation, NGOs can receive funding from all sources. In fact, the UN Declaration says they are free to receive funding from any other source. And the only factor is so long as it does not compromise the independence of that institution. So we have to look at what is the sort of funding given. Does it compromise that institution to do its work? If it doesn't, then the UN Declaration allows that NGOs or civil society can actually receive funding from any other source, which can include corporations.
We have one more question there, and then we have two more there. That will be the last one. So.
Hello, my name is Sela. I'm working for the Raoul Wallenberg Institute in Cambodia. As you are the special reporter, I would love to hear your difficulties working in different states of 45 countries. The reason I ask this short question is because we used to have 2 special reporters in Cambodia, and one special reporter, he was blamed by the Prime Minister, saying that his report is biased toward the civil society or NGOs. And then another special reporter comes in. He had similar problems, but at that time, the government used the students, a group of students, to attack him during the public debate or public forum like this. So I just would like to ask, to what extent that the state accept your report, and what are the difficulties to work with 45 different countries that you experienced in the past? Thank you.
Hello, thank you for your speech. I'm a student in the law faculty here, and actually I wanted to ask you, you suggested that to create a safer environment for the human rights defenders, they should develop a constant dialogue with the state. But actually, in the law framework of human rights, the statutes provide, leave the possibility for the state to limit the protection of human rights, at least in the European level. Well, I'm speaking for the right to free conscience, freedom of religion, and freedom of speech. So how you can link these 2 points, and in this dialogue and in the cooperation that you suggested with the supranational or United Nations institution, do the human rights defenders have always agree with all human rights statutes, or is there any development for the future? I hope you understand my question.
Not the last part. The last part is what?
Is it Is it granted that the human rights defenders should agree with all human rights statutes? Thank you.
This is Oscar Omondi. I'm a peace and conflict student from Malmo University. My question diverts a little bit from human rights to Okay, basically it's human rights, but I want to bring a case in point to you, a case that you might be well conversant with. The Kenyan case at the ICC, where the Kenyan president is accused of human rights violation. We have a case that has a problem because witness protection was not done so well by the ICC. So, does the UN or you as a rapporteur, when you worked for the UN, did you guys have an elaborate framework on witness protection, which in a nutshell, I would call witnesses to such a case as human rights defenders, because the guy who is accused at the ICC was accused of violation of human rights. And the witness protection was not done so well, and it was not done by the ICC, which is to blame on this particular case. Now the case is crumpling down simply because there was no very well witness protection. So it ended up the witness being intimidated and all that. I think is a case in point that you are very well conversant with. Thank you very much.
Okay. The first question was about the difficulties I've faced, acceptance about my report from countries and difficulties I might have encountered. And you gave me the examples of Cambodia. I must say that during my 6 years as UN Special Rapporteur, I had, at the beginning when I took over the mandate, it was difficult. And I said there is a way you have to, because it's the state which implements. Whatever you do, whatever you say, whatever reports you write, it's the state which is going to implement. Whatever resolutions you pass, whatever recommendations you pass, you are lobbying the state to be able to implement these recommendations. So you have to find a strategy of how you can get the states to comply or to implement what you've said. Let's say if you go for a country visit, you make recommendations in your country reports, you must make sure that the state is going to accept your report. Now, how do you do that? When you go for a country visit, you ensure that you meet state officials, you meet civil society, you meet the defenders, and then you discuss with them these issues. And normally, if your reports are factual, the state should be able to accept. If they are factual, they are based on facts which you found on the ground, the state should be able to take these reports into account. For the countries which I visited, for country visits, for example, there were 10. In fact, some of my reports were implemented by the states. Some of the recommendations were carried forward by the states. But for some countries which reject special rapporteurs or do not agree with them, I mean, there isn't much I can say about that. It depends on the country, it depends on the mandates, what it is. Of course, as you know, some of the country mandates, the countries have rejected the special rapporteurs. But as human rights defenders, I've not really had that problem with the countries I visited. The difficulties which I've had have been follow up on the recommendations which I've made to ensure that they are actually implemented. Some countries have requested for visits and they have not given me access, which means they keep on saying, we shall get back to you, or we are busy this year. They don't say an outright no, but they say, we shall get back to you, we shall come back to you sometime. So I write in my reports that countries should actually put a standing invitation as a best practice. And I think in most of the UPR processes, you see that most of the Human Rights Council requests for pledges is for the country to put a standing invitation for special rapporteurs. That will be the best practice. But of course, not all countries have standing invitations. But there are quite a number of countries which have standing invitations. Yeah, the other difficulty is about communications. When I issue communications and some countries don't respond, others respond, but in a very generic way. Yes, we shall investigate. We thank you for your communication. We shall investigate. Something like that, and they don't really give you the process and the process they are going to take and what the action they've taken. So these are some of implementation issues which even the UN is grappling with, issues of follow-up, issues of communications which are not responded to. But I must say that for the 6 years out of the communications I issued, we at least got a big percentage of responses from states. So, but it's not that there are no challenges, but some of the states respond, others don't, and you have to keep on reminding them and bringing out these issues within the Human Rights Council. And sometimes I feel that some of these issues should be raised. I put them in my observation reports, my communication observation reports, and I point out what the country has done or not done, and I then hope that the Human Rights Council would be able to take it up when they do the Universal Periodical Review. So the processes and the mechanisms should complement each other. Where sometimes we fail to get results, the other processes should be able to intervene. For example, if I fail to get a country visit, I expect that the Universal Periodical Review, the countries will call on that state to invite the special rapporteur. I call upon states to dialogue, special rapporteurs to dialogue with states. I think I've almost answered it. The states have limits to the freedoms, and then I'm at the same time saying that the rapporteurs should dialogue. In my experience, I found that even if you go and fight with them or aggressively take up the matter, you might not get the results. So the best thing is to dialogue with them if it's possible, to involve them in the programs, to say that we are doing this, we would like the state to be involved. Because as I said, it's the state which implements. You can make 1,000 reports, 1,000 resolutions. If the state is not going to adapt them, then you have not managed to achieve anything. So all efforts should be made to have constructive dialogue. And even the UN Declaration on Human Rights Defenders says there must be constructive dialogue with states. Should the special rapporteur agree with all human rights? We take into account the international instruments which we have signed, which we have agreed to, from the Bill of Rights, the Universal Declaration, the different conventions. And if we take into account those international instruments, then we should be able to support the rights which those instruments bring out, which espouse those rights. So you cannot say that the nations have come together to agree on international standards, and then they turn around and say, but we do not agree with this. So the measure is given, the standards are given, so let's comply with the standards, otherwise everybody will have his own standards. And we are calling on the community of nations to agree to basic minimum international standards which govern us. I don't know whether I should comment on the ICC. I've also just been following this on the news. As special rapporteur, I did not investigate whether the witnesses were intimidated. I don't know whether a ruling has been made that it was the case. I don't know whether this case is not sub judice for me to discuss it in detail and how my views are going to be taken. I would leave it in the wisdom of the courts of the ICC to make a proper judgment whether justice will be delivered, but it's not within my mandate to really judge because I haven't investigated. I have also just read it in the papers. So it's what you know is what I also know, that we hear from the press, and we would like to wait for the outcome of the case and see what happens. With the ICC, the countries have signed to the Rome Statute, and it's up to that particular country to follow what they've committed themselves to do. But I would leave this case of the ICC to the wisdom of the courts, which is going to deliberate on that, and I will follow with great interest. Thank you very much.
Dear Margaret, let me on behalf of the entire audience here thank you very much for that eloquent and interesting lecture. We really congratulate ourselves having been able to meet you here in Lund. I certainly agree with you that defending human rights is not only legitimate and honorable activity, it's a right of itself. It's a sad fact that defending and claiming human rights continues to be a dangerous activity in many parts of the world. There's a lot to be done, and we are all responsible to do that. And as you pointed out, it's fair to conclude that human rights defenders do work in the spirit of Raoul Wallenberg and Anna Lindh, believing that it's possible to make a difference. Standing up for universal values and human dignity is indeed needed when the respect for human rights threatened around the globe. As I said, these matters concern all of us. Thank you very much.